Going to start now. This is our 257th Friday group meeting. The speaker is our beloved senior advocate, topmost criminal lawyer of this country and former judge also. Sir also addressed our Friday group first time on 14th August 2015, that is 6th Friday group meeting. The topic was thoughts on the death sentence. The second time, that is 137th Friday group meeting. Irreversible breakdown of marriage. That's two times Sir Lordship, Sir addressed our Friday group. Sir, now you can initiate this please.
Good evening, G.Seshagiri Rao and all the studious members of the Friday group. It's always a pleasure to be with the Friday group. I've been watching with appreciation and admiration the manner in which the Friday group has been undertaking its academic activity. On a Friday evening, I know how difficult it is to get people. Kudos to Mr. Rao for pursuing it with single-minded devotion, and that perhaps is the reason why this 257th is 57th. It's not a small thing for such a group, with absolutely informal group, to continue on the 257th session is indeed very, very great. I'm very happy. Every time I've been saying this, I'm so happy to be associated with this. Thank you very much for this opportunity. Well, a topic has to be selected. There must be some controversy in the topic, then only it becomes interesting. Going to the first principles and speaking to you something about first principles may not be very attractive. Something which has disturbed you, something which you think is to you unacceptable, something which you think ought to change. Those are the things on which we can have a discussion, so that it would kindle, provoke thoughts in you. So I thought today, when it came up, we thought of taking up a topic like the one that is chosen: Draconian reverse burdens of the modern criminal law. Draconian reverse burdens of the modern criminal law. Section 29 of the POCSO Act is brought under the scanner very specifically, because I thought when I came across this section 29, I thought we have to unlearn many things that we have already learned. Section 29 of the POCSO Act is, according to me, shocking to a person versed in the criminal law that we are used to. And that is why I thought that topic might be of interest to you. I have a fairly, Sheshu said that I have fairly long interaction with the system. I've been a trial judge, and a trial judge means a grassroots level practitioner of criminal law during my first 15 years of my practice. Earlier 3 years as a law student also I was associated with the system, and the first 15 years as a trial court practitioner. The next about 15 years as a trial judge, district and session judge. I was a direct recruiting district judge. And the next 10 years as a judge of the High Court, the Kerala High Court. And the last about 13th, 14th year now as a senior counsel practicing here. Why I tell you this is that my interaction with the system has been long. And then traditional criminal law is perhaps taking a beating now. And that's where I think we can put our heads together and perhaps think why it's happening. You know, I need not tell you, the golden thread that runs through the entire fabric of our criminal justice system, both of the Anglo-Saxon and our Indian system, is of presumption of innocence and proof beyond reasonable doubt. This is the most fundamental of the fundamental principle of criminal law that we are all used to. That is, the golden thread is proof beyond reasonable doubt and presumption of innocence. These are perhaps the most fundamental of the fundamental principles that the Indian criminal law is. I would also like to tell you or ask you which is the system of law, that branch of law which concerns the most ordinary of ordinary people. I have no doubt that the criminal law is the one that interacts at the most lowest at the grassroots level, and therefore how the system of criminal law works, how administration of criminal justice takes place in a country, is indicative of the refinement of the system, of the refinement of the system of laws. Governance is always assessed by the common man by the yardstick as to how criminal law is administered. Everyone, that perhaps the state is constituted why? One of the reasons why the state is constituted is that state must afford protection for the citizen against the external aggression. Now it's very easy to explain that to you. Or internal disturbance. Internal disturbance, I say, is crime. The state has a duty to prevent internal disturbances. When you and I start from home in the morning, when we send our children and grandchildren out of the houses, we want to make sure that they are not affected by crime. The crime does not threaten them. The crime do not harm them. And that is one of the fundamental requirements of any orderly government, namely that people must be left free from crime. A modern constitutional republic has also the additional responsibility of ensuring right to life. Right to life is very important, and it has now been held many times. Right to life is not an existence, mere existence, or an animal life. It also means and includes a life by which you will be able to blossom into your fullness. It includes every known sublime concept of modern living, of life, means all these put together. And therefore the state is to ensure that the citizen has the right to life, which is a life of freedom from fear. If every day I have to worry about the crime that may fall on me, or may come on me or my children or my friends or grandchildren, it's not a right to life in its fullness. So I have to be taken away from the fear of crime also, not only from crime, but also the fear of crime. And therefore I would say the criminal law, the criminal justice system has got its duty to ensure that a person is free from the threat of crime or crime proper. That is the function of the modern criminal law. And how it functions, how effective it functions, is a reflection on the governance quality. Therefore, it's important that we have a system of criminal law where people are deterred from committing the crime. Punishment of the individual, exoneration of the innocent are all incidental role of the criminal justice system. Primary role is that we must have a crime-free state. Utopian, it will never happen. Crime-free state will never come into existence. But the endeavor is always to have a crime-free state. For which what should we do? People must be deterred from committing the crime. In order to deter them from committing the crime, the message must go around loud and clear in society that every criminal shall be punished. Right? It is a mechanism by which we deter people from committing the crime, by ensuring that every criminal will be punished. Of course, and that every innocent man will be exonerated too. It's a twin responsibility. Not one that can be squandered or sacrificed at the altar of the other. Both are equally important. We have lived long, for a very, very long period of time, ever since the British came to India, with a system of administration of criminal justice which has its roots in the Anglo-Saxon system. Is that the Indian system? I doubt. I very seriously doubt. We have borrowed the Anglo-Saxon system. The system that we have, as I always have been saying, does not have the fragrance of Mother Earth of India. It doesn't have the fragrance of Mother Earth. Law's common sense at mostly differs from my common sense. What is law? Law is the quintessence of the common sense of the community. If my common sense or the community's common sense is so different from the law's common sense, the system of law fails. Well, that perhaps is what is happening to Indian criminal justice system according to me. We don't have a system which has the fragrance of Mother Earth, which rhymes well with the common sense of the ordinary people of this country. I am not against presumption of innocence, I am not against the right to silence, but I think we have to Indianize it. We have to indigenize it. We have to customize it for our requirements, and then only our system of law would be foolproof, will be accepted by the people. I was wanting to ascertain statistics. The best statistic that we have is conviction rate is about 40%. What does that mean? What does that conviction rate convey to you? It means either that 60% of the people are being prosecuted unjustly. Correct? That's the first one. For 60% if they are entitled for acquittal, you are prosecuting them unnecessarily. The other option is 60% of the guilty people are going away unpunished, which also affects our system. If you have, I don't know, in the Supreme Court, I think lawyers do not have much of interaction with the grassroots level stakeholders. When I was practicing as a lawyer, like at your age when I was practicing, I could know how the system operates at the grassroots level. Every day clients who come to me, I know their manner in which they look at the system, how much they accept the system. And sitting here in the Supreme Court, I am deprived of that opportunity now, just as you may not have that, or the first-hand opportunity for that now. But I can tell you one thing, people are dissatisfied with the system. They don't think it's an effective system. They don't think that this system will take us to a crime-free state. They do not think that this system will achieve the dream of a crime-free state ever. That is why you will find people are thinking out of the box. People are thinking how to modify this system. All right, your Anglo-Saxon system, very good for you, but it doesn't rhyme well with my common sense. I want to change the system so that system of administration of criminal justice will be effective. An ordinary member of the polity does not worry whether it is Anglo-Saxon system or the continental system or a totally different Indian system. As they say, the cat must catch the rat. The cat can be white, brown or black, but it must serve its purpose. Now the question is our criminal justice system, our cat, able to catch the rats? If that is not so, we may have to tinker with the system and boldly innovate and find out how things can change. Well, that is perhaps a thinking, a discussion, a debate that is going on in our country today, which ought to go on in this country. I always say law is too serious a business to be left to the lawyer and the judge alone. The members of the polity have a right to discuss. They have a right to point out, your law is very good, all your technical principles right, it is not serving my purpose. It is not preventing crime. The message that should go around is crime shall not pay. But what is the message going on in our country today? Crimes do pay very much. It's very, very attractive to be a person willing to violate the law rather than be a law-abiding citizen like you and me. And therefore, people are justified in thinking, how can we change the law? How can we make law answerable to the demands of the polity? Well, I think the subject of our choice today, the draconian reverse burdens of the criminal law, is perhaps an indication of the malady that we have, that our system does not deliver the goods, and therefore, how do we change it? The presumption of innocence is very much there. It gives you the right to silence. The prosecutor frets and fumes to prove the guilt against you, right? You can take any defense, right? The classic example that I usually repeat is, the accused can first take the plea that I was not there at all. The plea of alibi, I was not there at all. And the great dictum of the Anglo-Saxon law says, you can take up the defense of alibi and private defense at the same time. In the same trial, you can take up both. Are we playing a complicated game, like the game of chess, where rules are more important than the game? Or are we trying in our courts to find out what is the truth? What happened really? Where is justice? For this, if the rules stand against that, should we not boldly innovate and change the rules also? Well, that is the dialogue, that's the debate that's going on now. And that is how this subject also arises for our discussion. There is the one first principle that we have to find out. Is presumption of innocence and proof beyond reasonable doubt, what right is that? Is it a natural right, as they call it? Is it a human right as we know now? Is it a statutory right which we have, or is it a fundamental right guaranteed under the Constitution? This question is very important. They say a natural right is a right which, whichever system you are born, whichever country you are born, whichever jurisprudence you are, I want a glass of water, can you, sir? Yeah, thank you. Whichever country, whichever age, whichever era, whichever state, whichever system you are born, every human being has certain rights which are described as the natural rights. It remains in the realm of politics and theory. I am not going to take you through that very much. Second is the human right. What is a human right? Now, a human right, I don't know how many of you are familiar with the Human Rights Act. Human Rights Act prescribes the Protection of Human Rights Act 1993 speaks of what a human right is. I don't have the time to take you through the verse, but a human right is all rights relating to freedom, liberty, independence, etc. of a person guaranteed under the Indian Constitution, and such other rights which are guaranteed under the international covenants to which India is a party. Please read the definition of human rights in the Protection of Human Rights Act. I will not take you through the decisions or the provisions. We don't have the time to do that. Already I am late, and then I shouldn't try to do that. But go through that. It is this. All rights, fundamental rights relating to life and liberty, freedom, which are guaranteed by the Indian Constitution, are human rights as per definition. All rights guaranteed under international covenants, you know those covenants, Civil Rights Act, the Human Rights Covenant, all those that are there, which under Article 51C of the Indian Constitution, the Republic of India is bound to honor, all those together would be a human right. Human rights are protected under this act. The remedies are given. Other than the ordinary laws, also there also many of the human rights are protected. So human rights are those rights which are guaranteed by let's say, they are defined under the Human Rights Act. Now we come to fundamental rights. Fundamental rights you find in Part 3 of the Indian Constitution. They are human rights also, as per this act. Now, fundamental rights are important because you know that under the Constitution, the legislative power of the state or even the amendment power of the state cannot cannot go beyond, cannot impinge on the fundamental rights of persons. If that happens, the legislation can be questioned. So a question arose, is the right to, or the presumption of innocence and the right to prove beyond reasonable doubt a fundamental right or not? Because if it is a fundamental right, legislature cannot trench upon it. And therefore a question arose whether this is a fundamental right or not. Presumption of innocence is a fundamental right or not. There has been a lot of debate on that. You know, Article 21 guarantees right to life, and then the various principles are incorporated. And therefore the question was, under the Indian criminal law, can a person claim the presumption of innocence and prove beyond reasonable doubt as a fundamental right? The question, according to me, is still open. One decision, Noor Aga decision, I'll just give you the citation. If you're interested, you go through that in greater detail. 2008 16 SCC 417. You can get it from Mr. Ronak if you want later, if you're interested. 2008 16 SCC 417. The Indian Supreme Court came to the conclusion, no, a very valuable right, but it has not been exalted to the position of a fundamental right. There is a lot of controversy on this. There are very many people who feel that the presumption of innocence and the proof beyond reasonable doubt, which is recognized under some of the charters, some of the covenants accepted by the Indian polity, must be recognized as a fundamental right. But let me tell you, so far, it has not been expressly recognized as a fundamental right. Those who are versed, who have an inquisitiveness, will always ask me, sir, have you not seen the, Satyendra Antil, what we described as the Antil decision by Justice Kaul and Sundaresh decision? You will find an observation there that presumption of innocence is a facet of Article 21, right to life. Well, we'll have to take it further from that. Is it a fundamental right or not? This is the only place where I find there is some discussion or some observation, not even a detailed discussion on that. While considering the right to bail, there is an observation in Antil that this is a facet of the fundamental right under Article 21. Well, we can carry things forward from that. It's possible for us to take it forward. And as you all know, today, right to privacy, which is not recognized under any of the provisions in the Constitution, has been accepted to be a fundamental right by enlargement of the interpretation of the right to life. If that is possible for a right like the right to privacy, I am thinking aloud now before you, not far away is the date where presumption of innocence and proof beyond reasonable doubt in a criminal case will also be recognized as an incident or a facet of the right to life. But let it be clearly understood, except this one observation which I have been able to trace in Antil, nowhere has it so far been held that the presumption of innocence or proof beyond reasonable doubt is a facet or a fundamental right which the legislature cannot trench upon. It's there. Why do reverse burdens come into the law? That is one question, the next question that I would like to discuss. I told you that people are dissatisfied with the system, they want to change it, they want the criminal law to be accountable, they want the criminal to be punished, criminals to be deterred, and therefore thought is going on as to how we can do it. Today, as I told you, the burden is on the prosecutor to prove everything. The accused need not open his mouth. The glorious right to silence, which we have accepted as a golden thread of our criminal law, permits him to just stand there and watch on the witness box as to what is happening in the trial. Mostly it becomes a drama, excuse me for using the word. Trials sometimes get reduced to a mere drama. As somebody said, he knows the truth, but he'll not open his mouth. Only one who does not know the truth is a poor judge. Both sides would know the truth, but the judge would not know the truth at all. I've been a judge, I know the agony of a judge in situations like that. But then, therefore, the thought comes that we can introduce presumptions in law by which certain facts can be presumed. Well, it may not rhyme well with your traditional concept of criminal law, where the entire burden is left at the doors of the prosecutor and the accused comes back and watches the show. So, the modern criminal law is trying to introduce methods, because the criminal is far ahead of the state today. Gone are the days when the state was very powerful and the criminal was powerless. Today the criminal is very, very powerful. He has technology at his command, he has resources at his command, he has devices at his command that he can take the state to awe. Terrorists funded from internationally can take our laws for a ride, and therefore to leave the entire burden on the prosecution may not in today's context be fair and just. And that is why the legislatures are now attempting to introduce reverse burdens or negative presumptions against the accused. It's interesting. Well, it is not as though this is for the first time that we have presumptions against. I'll take you through the law for some of the, just scan through the provisions and say that there has always been presumptions against the accused. The most fundamental of the presumptions is they may presume presumption under section 114 of the Evidence Act. You're all thorough with that. You must all have come across. It permits the court to presume certain things. I'll just show you that first presumption under 114 or the Evidence Act, which is just one by way of example to tell you that this reverse burden of the presumptions against the accused are not something which we introduced or imported now from thin air. It was always there, but the rigor of the presumptions are progressively increasing, and that is why we are discussing the reverse burden today. Let's just look at this 114. Court may presume existence of certain facts. Only the first one, A, that a man who is in possession of stolen goods soon after the theft is either the thief or has received the goods knowing it to be stolen, unless he can account for his possession. Well, see this, a classic example of a reverse burden not introduced in the modern criminal law, which was there even at the earliest point of time. When 1872 Indian Evidence Act came also, this presumption was there. It is a presumption of common sense. It's a presumption of how law can be worked. And therefore this presumption has always been there. What I'm trying to tell you is, as soon as we hear of reverse burdens, we have great antipathy to that. Even the topic I said, Draconian reverse burdens of the criminal law. We have a built-in prejudice against a presumption against an accused. Well, I think requirements of modern law being what it is, we all may have to be conversant with the reverse burdens and learn to accept them also. Where you cross the Rubicon is a different question. I'll come to that later. But burden on the accused, presumptions against the accused are going to stay in our system of jurisprudence. It's not going to change at all. Because I say it has always been there. From the time immemorial, whereas in the criminal law, the Anglo-Saxon criminal law started working, this was there. I'll give you one more example. 106 of the Evidence Act. You know what the 106 of the Evidence Act is? Facts within the special knowledge of a person, he has to prove. Well, if the accused has something in his special knowledge, it is up to him to prove that fact. Another instance of a reverse burden. The burden is cast on, it's not as though all the burden is on the prosecutor. 106 says, if you are the one, and a murder took place inside your house, your servant or your wife was killed, you are the only one available in the house. You say, I have the right to silence, I will not open my mouth. 106 says, no, you have a burden. So it's not as though the burden on an accused is something new introduced in modern laws. It is always there. More as a measure or an incident of common sense. Because under section 3, under section 3, the court accepts the law accepts the standards of an ordinary prudent person. What a prudent person would think is the yardstick under section 3 of the Evidence Act. And therefore you will find here, in 106 of the Evidence Act also, I can show you an instance of a reverse burden under law. Now I take you to 105. You know the provisions of the IPC which deal with general exceptions to criminality. Right to private defense, all those, mens rea, all those are defenses which are available under the section 105 says, court will presume absence of any general exception before it starts trial. And the burden is on the accused to prove that his case would come within one of the general exceptions of criminal law. That is again another instance of not a new modern principle brought in by modern criminal law. The erstwhile criminal law which has been enforced ever since the IPC was enacted, Evidence Act was enacted, these provisions were very much there. So reverse burden is not something which is unknown to even Anglo-Saxon criminal jurisprudence. Let's understand that. Now as time passes, we find newer presumptions coming in. Newer presumptions are coming into the criminal law. I'll just take you to a couple of presumptions. Say 114A. You know 114A of the Evidence Act? 114A of the Evidence Act says, normally the burden is on the prosecution in a rape case to prove that there was no consent. Right? You're aware of that. No consent is also an ingredient to be proved by the prosecution. Now section 114A for the first time said, for certain types of rapes, absence of consent can be presumed. Like for example, a pregnant lady. Like for example, a woman in a police station or a place of detention. There is no room for voluntary consent, and as an extension of the common sense principle, you find section 114 being enacted to say where the alleged rape is under certain circumstances, and the most outstanding circumstance I would point out is when a woman is pregnant, when a woman is in a place of detention. There is no place of voluntary consent, so the law says absence of consent can be presumed. Right? One more. See, we are making advances, and we are trenching into spaces hitherto a privilege enjoyed by the accused, that there will be no presumption against you, the burden will be on the prosecution. I take you to another section, 306 of the Evidence Act. 306 of the IPC, which is about abetment to suicide. Right? Abetment to suicide, the plight of the Indian bride in the matrimonial home attracted concern of the polity or the legislature, and therefore it was found it is very difficult for the prosecutor or the rest of the people to prove what happened inside the house, and therefore you find a presumption introduced. And what is the presumption? If unnatural death takes place within the matrimonial home within 7 years of marriage, the abetment of suicide is presumed, and the accused can disprove that. Look at another instance of reverse burden, because the state of things, state of affairs, state of criminal law warranted such a change, and that is why you find that. I'm not taking you to various other provisions. 304B, dowry death, the very draconian presumption, if I may call it so. 113B of the Evidence Act says that if death has occurred within 7 years of marriage, if it's an unnatural death, if it is if there is evidence soon before her death, she has been subjected to cruelty on the dowry cruelty, then you can presume. And it's very interesting that I have a great disagreement with that decision. What it said was, if it is shown, presumption can be drawn, but it has to be disproved if it is to be undone. And two judge bench of this court, you can get the citation, held that on preponderance of possibility, presumption can be drawn, but to rebut the presumption, that must be proved beyond reasonable doubt. One of the principles I would call most atrocious. I don't agree with that decision at all. To say that presumption can be drawn on preponderance of possibility, but it can be discharged only by proof beyond reasonable doubt, is the interpretation today valid under section 304B read with 113B. Again, an instance of a reverse burden brought into existence because it had to be done. The circumstances wanted it. Many examples can be given. NDPS Act, you find presumption. If you are found to be in possession, that your possession with the necessary mens rea is presumed. The Abkari Act, such a presumption is drawn. The UAPA Act, presumptions are drawn. All those, because of the peculiar challenges of criminal law from time to time, we find presumptions being drawn, presumptions being enacted to say, this will be presumed, and thereafter the burden is on you to rebut. All those you will find, for example, 34 of the 34 of the NDPS Act, not 34, what was section 37? No, 34. 34 of the NDPS Act says, if you are found to be in possession, then the requisite mental state is presumed. That is, you prove A fact, B state of mind will be presumed. Similarly in the Abkari Act, similarly in many enactments, it says, see, even 113B presumption, the prosecution must prove what? That the marriage was, death occurred within 7 years of marriage, that there was demand of dowry, that the person was subjected to matrimonial cruelty on demand of dowry, and that unnatural death has taken place. If these facts are proved, the offence shall be deemed to have been committed is the presumption under section 113B. See, certain facts are to be proved. On proof of certain facts, certain presumptions can be drawn. This was the scheme of many other reverse burdens. Internationally, under various, you will get the decision of the Canada Supreme Court, South African Supreme Court. You will get how this presumptions have to be, are they valid constitutionally or not, how they are to be tested, etc. You find that. But so far as our law is concerned, inasmuch it is not a fundamental right, that question did not arise earlier. Now you will find another new dimension. All of you are aware of the Maneka Gandhi decision. I suppose you must have read it in some context. Article 21 says, a person can be deprived of life and liberty by procedure established by law, right? Para 48, I'm not going to read it, I don't have the time. I would have loved to, but then I don't have the time to read it. Maneka Gandhi for the first time said, these stipulations of Article 21, the law must be fair, just and reasonable before it deprives a person of his right to freedom and liberty. It is not enough there is any law. The law may not offend fundamental rights. Even then Maneka Gandhi held that if the law offends the principles of fairness and reasonableness, then fair, just and reasonable, then the law cannot qualify to be procedure established by law, and therefore that can be. Now the thrust is on that. Even if not a fundamental right, in order to deprive a person of the right to life, which is a fundamental right, the law to be established must be not only be constitutionally valid, it must also answer the test of fairness, justness and reasonableness. It cannot be it cannot be capricious, arbitrary or irrational. Well, this is a new development which has come after Maneka Gandhi. Even though not expressly made a fundamental right, in order to deprive a person of his life and liberty, the law has to be fair, just, and reasonable, and it should not be capricious, arbitrary, or fanciful. Well, now we find the thrust being shifted to this part, and yet we are always arguing that the draconian reverse presumptions of law, of modern criminal law, are not fair, just, and reasonable. Well, that is a challenge open to it, open to the law fraternity now to challenge an infraction of the presumption of innocence and prove beyond reasonable doubt. Maybe you can say the law is irrational. Law is not fair. It's not just, and it cannot. Law which is not fair, just, and reasonable cannot entrench on my fundamental right to life. That is how this is being expanded. Well, I'll come to the subject that Section 29 of the POCSO Act. Are we getting very late? Another 15 minutes. Bear with me for another 15 minutes. I'm sorry I could not come in time because of the matter pending before the court, and I told. Now, very interesting presumption under Section 29. I want you all to read it, and this must irritate you. That's what I think. This must cause worry in you. This must cause anxiety in you. How can such a law be enacted in the Indian constitutional republic where there are a lot of protection in favor of an accused person? This I will read to you because it's very important for me. I want you to know this. It states like this: 29, presumption as to certain offences. Where a person is prosecuted for committing or abetting or attempting to commit any offence under Section 3, 5 and 7. They are sexual assault, aggravated sexual assault, penetrative sexual assault. These three sections. Where a person is prosecuted for committing or abetting or attempting to commit any offence under Sections 3, 5, 7 and 9 of this Act, the special court shall presume that such person has committed or abetted or attempted to commit the offence, as the case may be, unless the contrary is proved. Look at the nature of the presumption. My sense of justice is shaken when I read this provision. It says when a person is prosecuted for these offences, the special court can presume that he has committed the offence. Nothing need be proved. If I were the prosecutor, I would have gone before the court, put the investigating officer as PW1, and he would have said, I got a complaint from the victim, I registered a crime, I investigated, I filed a charge sheet, I presented the charge sheet, the court issued summons, and then the court sent the charge against him. And then say, thank you very much. Because once this is done, nothing more need be proved. I repeat, what you should know is where a person is prosecuted for committing the offences under so and so, so and so, the court shall presume what? Presume that he is guilty. I took you to the various other provisions which says, prove X fact, Y fact can be presumed. Prove X, Y, Z facts, facts that can be presumed. And the burden is on him to controvert. Look at the section, all that is said is, if you are prosecuted, you are presumed to be innocent. Is it a police state? Is it an authoritarian state? Is it an autocratic state where you can have a presumption like this in a country wedded to constitutionalism? Can you have a presumption like this? All that need be proved is that you have been prosecuted. Well, I would have wanted the alert judiciary in this country to strike down this provision as quickly as possible. It should have been struck down as unconstitutional. It is not law which is fair, just and reasonable under the Maneka doctrine. Even assuming that presumption of innocence, deprivation of life and liberty is not a fundamental right, even then this presumption offends my basic sense of justice and reasonableness that it could not have been. But interestingly, you will find this provision has been subjected to challenge under various other grounds But a direct challenge on constitutionality has not yet come before the court, except before the Kerala High Court in one decision. I'll take you to that. That is the only instance where the constitutionality of this provision is directly challenged. 3 times the Supreme Court of India had occasion to consider this question. Those 3 decisions taken from him, 3 times it considered. It did not consider the constitutionality, it considered whether the presumption can be drawn. On various situations this came. First question was, what do you mean by the word prosecuted? When a person is prosecuted alone, this presumption can be drawn. When can you say a person is prosecuted? When the complainant victim files an FIS, can you say he is being prosecuted? When the investigating officer registers an FIR and he starts investigation, can you say he is prosecuted? When he is arrested and taken into custody and remanded by the magistrate, can you say he is prosecuted? When the charge sheet is ultimately filed, can you say he is prosecuted? When cognizance is taken and summons is issued against the accused, can you say he is prosecuted? If after considering the entire materials before it, the court frames a charge, then at least can you say he is prosecuted? This came up in different situations. Like in a bail application, when it came up, the prosecutor argued, presumption under section 29 is there. When he is prosecuted, he has to be presumed to be guilty. So you can't grant him bail at all. In another case, he said maybe not when the bail application, but after the charge sheet is filed, at least it must be drawn. So, under various shades this challenge, what does the expression prosecuted mean? That came up for challenge. You will get those decisions, some of the high courts held that as soon as the FIR is registered, it comes in. Even for a bail application, this presumption can be drawn. All those various things came. But I believe courts with a conscience were not able to accept this as it is. And courts increasingly held, tried to play on the word prosecuted and tried to delay the presumption. They did not tackle the bull by the horns and said, this presumption is unconstitutional. You cannot draw this presumption. They didn't say that, but those decisions, the 3 decisions of the Supreme Court, you will see them, they considered this and said that yes, presumption can be drawn, but not at the stage when the complainant files an application. Not at the stage when the FIR is registered. Not when he is arrested. So, at the stage of granting bail, this presumption will not apply. It appears to be the law now. That's not by the Supreme Court, that's by one High Court. So that cannot be done. So then the question is, ultimately what they said was, foundational facts have to be proved, then only the presumption can be drawn. I fail to understand. I appreciate the anxiety of the judges not to make this the law. But then what are the foundational facts? Read section 29, where is it said that foundational facts are to be proved? See, read 114A, which says, if you are found in possession of stolen property, then certain presumptions will be drawn against you. Abetment of suicide. If the wife commits suicide within such a time and certain facts are proved, it will be presumed that you have abetted. Like that 304B, like that NDPS Act, presumption of mens rea. But where is the fundamental fact in this? Read it again and again and again. I have tried to do it. I have not been able to read into this the requirement that fundamental facts are to be proved, and if so, what those fundamental facts are. The statute does not give you a guideline as to which fundamental fact has to be proved before the presumption under 39 can be drawn. It doesn't say that. The presumption under 29 can be drawn. It doesn't say that. But courts, in their anxiety to read down this provision, the High Courts as also the Supreme Court have said that presumption is very much there, but it can be drawn only after framing the charge. That appears to be the common thing now. And some of the High Courts also said only after the evidence is adduced. The courts tell that only after foundational facts are proved. Not saying what are the foundational facts. Well, I think this provision deserves to be thrown out of the statute book as early as possible, because according to me, this does not prescribe a fair, just and reasonable procedure. Whether the a presumption of innocence be a fundamental right or not a fundamental right, this presumption, this offends the law. This completely offends the law. I reckon it as a fundamental right is a most unreasonable restriction on the fundamental right of an individual. Reckon it as a law which prescribes procedure for taking away life and liberty under Article 21, then again this law is not fair, just and reasonable. It deserves to be struck down. Well, Indian law has not advanced much on this concept of the constitutionality of the presumption of innocence and the insistence on reasonable proof beyond reasonable doubt in a criminal case when it comes to. Presumptions are justified. I will never argue for the proposition that presumptions cannot be drawn. That is why, to disabuse any incorrect impression, I started with 114A and said that such presumptions have always been there. But not a presumption like this which offends your sense of justice. Which says as soon as a person is prosecuted, who decides on prosecution? Who decides on prosecution? A sub-inspector of police can file a charge sheet against you under this, and with his filing of the charge sheet, I am presumed to be guilty. Well, this part of the law has not been tested. Very unfortunately, I find it's time that some of us take up the question before the Supreme Court and then get it challenged. This provision, according to me, the earlier you take it out from the statute book and dump it in the waste basket, the better for us. This presumption is illegal, it is oppressive, it is arbitrary, it does not satisfy the test of fair, just and reasonable as insisted by Maneka Gandhi. Well, one decision, with that I am closing now, with one decision I would like to say, two judges, Justice Oak and Justice Gupta, when they were in the Bombay High Court, have laid down the principle which appeals to me very much. I think it's very, very good that we must all be enlightened of the principles in that decision. It is there in 2016 SCC Online Bombay 2600. You will get it from me if you want. Once again I repeat, 2016 SCC Online Bombay 2600. According to me, this decision authored by Justice Oak is a locus classicus on the question as to how a reverse burden can be held to be constitutional. A reverse burden which does not satisfy the test of just, fair and reasonable, even assuming it is not a fundamental right, cannot be held to be valid law. Just read paragraphs 240 and 241 of this decision. I think it shows the manner in which the eminent judges have culled out the principles and said how a reverse burden has to be considered under the Indian law to be constitutional. Well, it's a decision by the High Court. It has not come up here. Somewhere, someday, sooner than later, I believe, I hope, I wish that the constitutionality of this provision will come up before the Supreme Court, and the Supreme Court will not waste time in declaring this law to be unconstitutional. Thank you very much. It has been a pleasure. There are some more things that I wanted to say, but I think some of them too late. No.
Thank you very much, sir. Very nicely explained. I mean, such a important topic. Man, you are so much busy, even though you make it out of the way. Sir is so busy in the court number 15. Just he made a commitment to the Friday group. So we have to appreciate sir's this thing, give a huge clap.
I was 3 minutes late. I'm sorry for that.
So nicely explained on presumption parts, sir, particularly. So we have to see the challenging in the court. I mean, we'll take your help and other thing. And now I request Niharika will say vote of thanks.
Good evening, everyone. It is an honor being part of this educative and purposeful session today. First and foremost, I would like to extend sincere thanks from all of us, sir, to you. Thank you for elaborating on the topic Draconian Reverse Burdens of Modern Criminal Law with Section 29 of POCSO Act, and also elaborating on the provisions of Evidence Act and how they have always existed in our
Science.
legal system, being reverse burdens. We are truly grateful for this in-depth knowledge that you have shared today, sir. Secondly, I would like to thank G.Seshagiri Rao sir for giving me this opportunity, and thank you all for your time and consideration and peaceful environment for making this session a success. Thank you all.
Thank you, Niharika.